Jai Hind everyone. Welcome to my YouTube channel, which is Explore Yourselves, Banking and General Knowledge, etc. Today I'm going to describe about SARFA ESI Act 2002, Part 1, Authority of Authorized Officer and Initiation of SARFA ESI Proceedings. Introduction. The Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, SARFA ESI Act, is an important legal framework that empowers banks and financial institutions to recover their dues from defaulting borrowers without approaching the court initially. However, the process must be followed strictly according to the provisions of the Act and related rules. The role of the authorized officer, AO, identification of non-performing assets, NPA, issuance of notice, service procedure, and handling borrowers' representation are important stages in initiating SARFA ESI proceedings. First, who is an authorized officer? AO. The SARFA process begins with an authorized officer who has the legal authority to initiate recovery action. As per the Security Interest Enforcement Rules 2002, an authorized officer should generally be an officer not below the rank of chief manager or equivalent. The officer must be specifically authorized by the board of the bank or financial institution to take action under the SARFA Act. The authorized officer plays a crucial role in and is empowered to issue a demand notice under Section 13 to take possession of secured assets under Section 13(4), conduct auction proceedings, and issue sale certificates after completion of the required legal process. Proper authorization is essential because if SARFA ESI action is initiated by an officer who is not legally empowered, the borrower may challenge the proceedings before the debt recovery tribunal. Second, identification of NPA before starting SARFA ESI action. Before initiating SARFA ESI proceedings, the authorized officer must ensure that certain important conditions are fulfilled. First, account classification as NPA. The borrower's loan account must be classified as a non-performing asset NPA according to the guidelines issued by the Reserve Bank of India (RBI). SARFA ESI action cannot normally begin use unless the account has reached NPA status. B. Existence of security interest. The loan should be backed by a valid security interest such as mortgage, hypothecation, pledge, or other enforceable security created in favor of the bank or financial institution. Second, identification of NPA before starting SARFA ESI action. Before initiating SARFA ESI proceedings, the authorized officer must ensure that certain important conditions are fulfilled. C. Legal recoverability and limitation. The outstanding debt should be legally recoverable and should fall within the applicable limitation period. Proper documentation and enforceability of the loan agreement are important before taking action. D. Registration with CERSAI. The security interest should be registered with the Central Registry of Securitization, Asset Reconstruction and Security Interest of India (CERSAI), ensuring proper recording of the charge created on secured assets. Third, issuance of demand notice under Section 13(2). After confirming eligibility, the authorized officer issues demand notice under Section 13(2) of the SARFA ESI Act. The main purpose of this notice is to formally demand repayment of the outstanding dues from the borrower. The borrower is provided 60 days time from the date of receipt of the notice to clear the outstanding amount. The notice generally contains important details such as A. Total outstanding dues payable by the borrower, B. Details regarding the default committed, C. Description of the secured assets, D. Consequences of failure to repay within the given period. After receiving the notice, the borrower is restricted from transferring, selling, or creating any third party interest in the secured assets without the consent of the secured creditor. Fourth, service of notice to borrower. Proper service of the Action 13(2) of the Section 13(2) notice is an essential part of the SARFAESI process. The authorized officer must ensure that the notice reaches the borrower through acceptable communication methods. The notice may be served through A. Registered post, B. Speed post, C. Courier service, D. Email communication wherever applicable. If the notice is returned as unserved, further steps may be taken, including the publication in newspapers and a fixation of the notice at the property, residence, or business premises of the borrower as per applicable rules. Maintaining proper proof of service is extremely important because it establishes that the borrower was given a fair opportunity before further recovery action. If the borrower's representation or objection. After receiving the Section 13(2) notice, the borrower has the right to submit objections, legal representations, or settlement proposals to the authorized officer. The borrower may raise issues relating to A. Incorrect calculation of dues, B. Validity of the recovery action, C. Documentation related concerns, D. Any other relevant legal or factual objections. The authorized officer has the responsibility to carefully examine all objections received from the borrower. The officer must consider the submissions and provide a reasoned reply explaining whether the objections are accepted or rejected. The reply should generally be provided within 15 days, making it a mandatory requirement under the SARFAESI framework. Conclusion: the SARFAESI Act provides banks and financial institutions with a powerful mechanism for recovery of secured loans, but the entire process depends on strict compliance with legal requirements. From appointment of a properly authorized officer to identification of NPA, issuance and service of demand notice, and consideration of borrower objections, every step must be completed carefully and transparently. Following due process protects the rights of both lenders and borrowers and ensures that recovery proceedings remain legally valid. Disclaimer: this information is prepared for educational and awareness purposes based on publicly available information regarding the SAR-FAESI Act 2002 and related rules. It is not a substitute for professional legal advice. For specific cases, interpretations, or recovery proceedings, readers should consult qualified legal professionals or refer to official notifications, RBI guidelines, and statutory provisions. Thank you very much for your patience. Please like and share this video and subscribe to my YouTube channel.